ever clock in those extra hours and, expect to see that sweet, sweet overtime pay.
Oh, yeah.
For millions of us, the Fair Labor Standards Act, or FLSA, is kind of the unseen hand guaranteeing minimum wage and those extra earnings for the long weeks.
Absolutely fundamental.
But what happens when that expectation hits a legal wall? Specifically, how an employer classifies your job.
That's the core issue here.
Today, we're diving into a unanimous Supreme Court decision that, well, on the surface, it looks like just a subtle legal tweak.
Technical, yeah.
But for businesses and employees across the country, it's actually a significant shift in how the burden of proof works when an employer claims a worker is exempt from overtime.
A really big deal, potentially.
We're talking about the case of EMD Sales, Inc. et al. v. Carrera et al., decided January 15, 2025. This ruling really changes the game for how federal labor laws are applied.
It sets a new precedent nationwide.
So in this deep dive, we're going to peel back the layers of this decision, trying to understand what these standards of proof actually mean in a courtroom.
Yeah, demystify that a bit.
And uncover the surprising ways this technicality could shake up your workplace, whether you're an employee, a manager, or, business owner.
It touches everyone.
Our mission is basically to make sense of this legal language and highlight its very real impact on your professional life.
Exactly. Bring it down to earth.
So, okay, to set the stage, let's talk about the bedrock of worker protections. The Fair Labor Standards Act.
The FLSA. Yep.
It's often called the wage and hour law, and for good reason. It lays down those basic rules, minimum wage, overtime.
The essentials.
But, and this is where it gets tricky, it also carves out exceptions, doesn't it?
That's right. The FLSA is a true cornerstone, like you said, signed into effect by FDR way back in 1938.
Wow, 1938.
Yeah. And at its heart, it guarantees that federal minimum wage and generally requires overtime pay if you work more than 40 hours a week. Protections many of us just sort of expect.
Take for granted, maybe.
Maybe, yeah. But Congress knew that not every job fits neatly into that 40-hour-plus overtime model, so they created what are called exemptions.
Okay.
Think of it like general rules, but with specific carve-outs. These exempt employees can range wildly. Baseball players, seamen, even maple syrup processors.
Maple syrup processors, seriously.
Seriously. Along with, software engineers, firefighters, the list goes on. The idea is that for certain roles, the standard rules might not make practical sense.
So an employer can say, hey, this role, exempt, no overtime. But I'm reading that the burden, it's like, who has to prove that? It's not the employee, is it?
Great question, and it's absolutely crucial. The law places the burden squarely on the employer.
Okay.
It's not the employee's job to prove they aren't exempt. It's the employer who has to show, convincingly, that a worker fits one of these specific exempt categories.
Gotcha.
And for our deep dive today, the really relevant exemption is for an outside salesman. That means someone whose main duty is making sales and who regularly works away from the company's main office.
Okay, that makes sense. So with that foundation, how did this specific situation unfold? Let's talk about EMD Sales and their workers. This is where the legal fight really started.
Indeed. The company is EMD Sales, Inc., a food distributor down in the Washington, D.C. area.
Okay.
They employed sales representatives whose job involved managing inventory, taking orders at grocery stores, that kind of thing.
Right.
The dispute kicked off when several of these reps sued EMD. They claimed they weren't getting paid overtime, which they believed the FLSA required.
And EMD's response.
EMD countered, arguing that these sales reps fell under that outside salesman exemption we just talked about.
Oh.
So according to EMD, no overtime was due.
Right.
The initial trial at the district court level actually found EMD responsible. They had to pay the overtime.
So the employees won the first round.
They did. The court determined EMD hadn't proven their employees qualified as outside salesmen. And crucially, the court said EMD failed to meet this standard by clear and convincing evidence.
Ah, that specific phrase again.
Exactly. The court felt the reps were mostly just servicing existing accounts, not really making new sales in the way the exemption requires. So EMD challenged this, arguing the court used too high a standard, too tough a bar for proof.
So EMD appeals, saying, hold on, that clear and convincing standard is too much. But the appeals court, the Fourth Circuit, they didn't agree, did they? They stuck to it.
They stuck to their guns, yeah. They affirmed the district court's judgment following their own circuit's precedent, which did require clear and convincing evidence for FLSA exemptions.
Okay, so far consistent within that circuit. But what makes this part of the story so important is that the Fourth Circuit was basically out on a limb, right? They were the odd one out.
Absolutely. That's what makes this fascinating. The Fourth Circuit stood completely alone in this interpretation. Every other federal appeals court that had looked at this issue, the 5th, 6th, 7th, 9th, 10th, 11th circuits,
Pretty much everyone else.
pretty much, they all applied a less stringent standard, known as the preponderance of the evidence standard.
Yep.
This nationwide disagreement, the circuit split, as lawyers call it, meant the rules were different depending on where you were. Huge inconsistency.
Which is bad for business, bad for employees.
Yeah.
Just confusing.
Exactly. And that's precisely why the Supreme Court had to step in. They granted certiorari, agreed to hear the case, to settle the dispute and create one uniform rule for the whole country.
That national disagreement really underscores how a technical legal term can lead to totally different results just based on geography. So let's unpack these standards of proof. We hear beyond a reasonable doubt on TV all the time.
Right, for criminal cases.
But how do preponderance of the evidence and clear and convincing evidence actually work in a civil case like this one, affecting, your potential overtime pay?
It's a vital distinction, really, as understanding it is key to this whole decision. Let's break down the two main ones here.
Okay.
First, you've got preponderance of the evidence. This is the standard, the default setting, in most American civil litigation.
Like the basic one.
Exactly. In simple terms, it just means more likely than not. Think of those classic scales of justice. If the evidence tips the scale even slightly, just 50.1% in one direction.
Just barely.
Just barely. That side has met the preponderance standard. It just needs to be slightly more probable than not. The idea is that both parties share the risk of an error, roughly equally.
Okay, more likely than not. Got it. What's the other one?
The other one is clear and convincing evidence. Now, this is a significantly higher bar.
Harder to meet.
Much harder. Here, the evidence has to be substantially more likely to be true. The person deciding the case, the judge or jury, must be firmly convinced.
Firmly convinced. That sounds much stronger.
It is. Back to the scales. This isn't just a slight tilt. It's a definite, significant shift. You're not just leaning, you are convinced by the evidence. It's much tougher for the party with the burden of proof, in this case the employer, trying to prove the exemption.
So it's like a middle ground between more likely than not and beyond a reasonable doubt.
Precisely. It's reserved for cases that are more serious than typical civil disputes, but don't involve potential criminal conviction.
Okay, slight lean versus firm conviction. That really clarifies it. So now, the main event. The Supreme Court's unanimous decision. Justice Kavanaugh wrote it. Why did they ultimately land on the lower standard, the preponderance one, for these FLSA exemptions? Why was more likely than not enough?
Right. The court's reasoning was pretty straightforward, hitting three main points. First, and this is a big one in legal interpretation, the FLSA itself, the actual text of the law, is silent. It doesn't say which standard of proof applies to exemptions.
Congress didn't specify.
Exactly. And the court's traditional approach is, when a civil statute is silent on the standard of proof, you apply the default. The default is preponderance.
So if Congress wanted higher, they should have written it in.
That's the logic. Statutory silence usually means you stick with the norm, not create a special higher hurdle.
Okay, point one, the law was silent. What else?
Second, this case didn't involve any of those fundamental constitutional rights that typically trigger a higher standard.
Like free speech or something.
Exactly. The court usually requires clear and convincing evidence only in specific serious situations like First Amendment cases involving libel or really serious due process cases concerning things like involuntary civil commitment.
Wow.
Or terminating parental rights, things with fundamental liberty or family integrity is at stake. Overtime pay, while important, doesn't rise to that constitutional level, demanding a special standard.
Makes sense. And the third reason?
Third, this wasn't one of those really rare situations involving unusual coercive government action. Say, the government trying to revoke someone's citizenship. That's a drastic action needing a higher proof standard. This case was about money damages, getting paid correctly. The court called it conventional relief. It wasn't government overreach in that extreme sense.
So standard civil dispute, basically.
Pretty much. And they drew a parallel, saying FLSA cases are a lot like employment discrimination cases under Title VII.
Oh, okay.
And in Title VII cases, the court has consistently used the preponderance standard. So the reasoning was, if preponderance is good enough for proving discrimination, it should be good enough for proving an FLSA exemption. consistency again.
That tracks. Consistency across similar areas of employment law. But look, the employees and worker advocates generally, they had some pretty strong arguments for keeping that higher, clear, and convincing standard, didn't they? Policy reasons.
They certainly did, and their points weren't frivolous at all.
What were they saying?
Well, one core argument was that the FLSA isn't just about individual paychecks. It protects the public interest. You know, a stable economy, fair wages for everyone. Therefore, making it harder for employers to claim an exemption serves that public good.
Sounds reasonable. How did the court respond?
The court acknowledged the public interest aspect, but pointed back to Title VII again. They said, look, eradicating discrimination also serves a vital public interest, arguably just as much, but we still use the preponderance standard there.
Wow.
They basically said, our job is to apply the law Congress wrote, not to weigh competing policy goals and choose sides by imposing a higher standard Congress didn't ask for.
Okay, so public interest wasn't enough. What else?
Another argument was about waivability. FLSA rights, like minimum wage and overtime, generally can't be waived by an employee. They argued this special non-waivable status means proving an exemption to those rights should require more proof.
Like they're extra important rights.
Exactly. But the court separated the two concepts. They said whether a right can be waived is a different question from what standard of proof applies in court.
How so?
They gave examples, like a criminal defendant can waive their right to a trial by pleading guilty, even though the standard of proof for conviction at trial is the highest one, beyond a reasonable doubt. So non-waivability doesn't automatically mean a higher proof standard for related issues.
Interesting distinction. Was there a third argument?
Yes, and it was a practical one. The employees argued that employers usually control most of the evidence, timesheets, job descriptions, internal memos.
Right, the company has the records.
Exactly. And often, the employees in these cases might have lower incomes, making it harder for them to finance a big legal fight. So they argued a higher standard for the employer helps level the playing field.
That seems like a very real-world concern.
It is, and the court acknowledged it, even citing a recent case mentioning that employers often hold most of the cards in litigation. But again, they pointed to Title VII.
Same issue there.
Same issue there. Plaintiffs in discrimination cases can also be low income, and the employer often controls key evidence. Yet, the standard remains preponderance. So the court concluded, so too here. If it applies in Title VII, it applies in FLSA exemption cases.
So despite the policy arguments, the court really stuck to legal precedent and consistency with similar laws. Let's bring it back to the here and now then. What does this ruling actually mean for people? For you listening, whether you manage a team, work for a company, or just try to figure out workplace rules.
Okay, the practical takeaways. For employers, this decision generally makes their lives a bit easier, legally speaking, when asserting an exemption.
Lower burden.
Lower burden. It could make it less risky for businesses to classify workers in roles that don't get overtime pay. It might reduce potential liability and labor costs. If you're a business owner, your lawyer's advice just shifted slightly. You now only need to be prepared to show it's more likely than not that the exemption fits.
Which could definitely influence how roles are structured or paid.
Potentially, yes. Now, conversely, for employees,
Harder for them.
it could make it somewhat harder to win an overtime claim if your employer argues you're exempt, because the employer now faces that less demanding preponderance standard in court.
So if you're an employee.
It really underscores the importance of understanding exactly how your job is classified, what your official duties are, and whether they truly align with one of the FLSA exemptions. Knowledge is power here.
Definitely. And what happened to the actual EMD sales case?
The Supreme Court didn't decide if the workers were exempt or not. They reversed the Fourth Circuit's decision that used the wrong standard and sent the case back down.
So they have to reevaluate.
Exactly. The lower courts now have to look at the facts again, but this time using the more likely than not standard to decide if those sales reps were truly outside salesmen. The outcome for those specific employees could absolutely change.
And for the rest of the country.
Well, the biggest impact is uniformity. This decision brings the Fourth Circuit into line with all the other circuits.
One rule nationwide.
One rule. It clarifies the law, removes that inconsistency, and hopefully provides more predictability for both businesses and workers, regardless of where they happen to be.
Yeah, predictability is usually a good thing in law. So this deep dive into EMD sales v. Carrera really shows how something that sounds super technical, a standard of proof, can ripple out and affect millions of us.
Absolutely.
It's a potent reminder that these legal decisions aren't just abstract concepts. They're about real people, real jobs, real paychecks.
Affecting everyone from, the person stocking shelves to the CEO. And it does raise an important question for you, the listener.
Yeah.
As you think about this, consider your own workplace. How might this shift influence how roles are defined? Might employers feel more confident classifying certain jobs as exempt now?
Or how should you, as an employee, think about your own classification and rights?
Exactly. It's subtle, but the ripple effects could be significant. It just makes being informed about your specific situation even more critical.
Definitely. And for you, the curious learner tuning in, this isn't just about one court case. It's about understanding those almost hidden mechanics that govern our work lives.
The gears behind the scenes.
Right. It reminds us that fairness in the economy isn't just about the big rules written down, but also about how strictly those rules have to be proven when disagreements arise. Something to chew on as you navigate your own career, making sure you're armed with as much knowledge as possible.